welcome everyone. I'm Cynthia Canner. I'm Executive Director of Prairie State Conservation Coalition, and very, very happy to see you all here today, this afternoon, on a beautiful day, at least up in Northern Illinois. And I hope it's a great day wherever you are tuning in from. And this is our second Conservation Connector. It's a new series, and I will announce our next one, which is next month, at the end of this program. And today we've got two awesome speakers who some of you are very familiar with. I'm very excited to have this program on anatomy of a land deal, and it's focusing on conservation easements. I met our speaker, Chris Guchenritter, up at the Gathering Waters conference back in May to get ideas for PSCC's very own conference, and really enjoyed his presentation and just thought, I've got to get him to either move to Illinois or at least talk to us. So, Chris, just very excited to have you here today. And Chris is Director of Land Conservation Law Program at Gathering Waters, which is the Association of Land Trusts in Wisconsin. And Dave Holman is an independent contractor and GIS guru. And a lot of you know him through the wonderful annual report he produces for PSCC on behalf of land and the increase of land protection, both public and private, all over the state of Illinois. And it's a wonderful report that's always available through our website. So I am going to kick it off to our speakers and let you guys take it from here. And I'll be monitoring the chat for anyone who has questions. And I have permission to interrupt our illustrious speakers as we go along. So welcome and take it away.
Thanks, Cynthia. As Cynthia said, my name is Chris Guchenritter. I am the Director of Land Conservation Law Program at Gathering Waters up in Wisconsin. Despite the generous invitation, I don't think I'll relocate to south of the border. I've been working with Dave for, Dave, 6 years-ish, probably.
3 or 4, maybe.
7? No,
we're not that long. Well, who knows? Several years at the very least.
Yeah. So prior to my position here, I was a staff member of a land trust in southeastern Wisconsin, and came to learn of the work that Dave was doing and began to develop a relationship with Dave, and I feel like we've mutually supported each other's growth and innovation in land conservation strategies. And so today we're going to talk a little bit about what we're calling anatomy of a deal. It was interesting to me to learn from conversation with Cynthia and Dave that when you compare conservation strategies in Wisconsin to those in Illinois, the proportion of conservation easements as a conservation tool is being used far more frequently here in Wisconsin than it is in Illinois. So because of that, we've elected to focus today on anatomy of a conservation easement deal, as opposed to more generally a conservation deal, which might include fee simple transactions. So I'm an attorney, and in my role with Gathering Waters, I represent Wisconsin land trusts in conservation transactions, and also do sort of peer-to-peer training with other attorneys, and also with land trust staff and board members alike. So that's a little bit about my background. I'm getting the impression that most, if not everybody on this call, knows Dave. Not to say that we don't want Dave to have an introduction and all those things, but if you all know him,
Dave doesn't like being the center of attention regardless, so I am all about moving right into the topic of discussion.
All right. So we're going to talk today through the lens and the framework of the Land Trust Alliance standards and practices. There's kind of a built-in assumption when we're talking about conservation easement transactions that we're talking about, or we're at least talking to folks who are either on staff at land trusts or board members of land trusts. And but the essence of what we're talking about also applies to municipal entities, counties, and sewerage districts, and any easement holder out there. So although we're using the LTA standards and practices which apply to land trusts, accredited land trusts, the substance of what we're talking about would apply to any easement holder. So within the standards and practices, of which there are 12 standards, and within each standard there are a subset of practices to achieve that standard. A number of them directly implicate the actual easement transaction as opposed to how your organization functions as a land trust or a 501c3 nonprofit, whatever the case might be. And so we're going to focus in on two in particular, standard number 8 and standard number 9. We will touch on number 3, which is board accountability. We will touch on number 6, which is financial oversight. But we're really going to focus for the next 45 minutes or so on the planning and the ensuring sound transactions. So there are some trends happening in conservation, and in preparing for our conference, we sort of polled land trusts, and the results of that poll showed us that as a result of these trends, and I won't necessarily get into the trends, but let's say COVID was a major driver for much of these trends. Land trusts are having to be much more strategic and much more efficient. And that's forcing us to reconsider the projects that we are taking on as a land trust community for conservation easements. And so that's what I mean when I say live in the sweet spot. So we've got these opportunistic projects, and then we've got these priority projects. And these priority projects are the ones that are going to show up when you're doing your strategic plan. They're going to show up when you're looking at your landscape and identifying key environmental resources that really need some support or would do well with permanent protection. And then, of course, those opportunistic ones are the ones where you get a phone call or you get an email from a landowner who says, my family's doing some estate planning. We've got a 150-acre property and we'd like to protect it. And you've never even heard the landowner's name before. That may be an opportunistic land conservation transaction in front of you. So in order to live in that sweet spot, the land trusts really need to focus in and zero in on not only how to be prepared for those sweet spot opportunities that show up when opportunity and priority overlap, but also how to dedicate resources efficiently to those projects. I should say this, part of context is one of those trends that we did notice was funding is becoming challenging.
Which is something worth emphasizing. I'll just jump in really quickly. Chris, you commented earlier that easements are a more prevalently used instrument north of the border than they are down here in Illinois. And I think in part that's because there has historically been foundation funding available down here. We don't have something like Knowles Nelson, but it's it's been pretty prevalent. That's going away now. In a couple of years, most of the major funders will have closed up shop. So easements, I think, are going to take on added importance. And Chris, I'm going to toss it back to you.
Yeah. So that's a good point to be made, because these trends that sort of influenced our conference really did show us that it's not so much that money's drying up here in Wisconsin, but the sources are shifting, and it's, in many cases, they're becoming more challenging to get to. So all that is to say is that our land trusts really need to be more efficient and more effective in the work that they're doing to achieve their conservation outcomes. Due diligence requirements are becoming more demanding. We were also noticing an aging out of experience the appraisers, the attorneys, the surveyors, all those folks that we all rely on to do conservation transactions are either electing to move out of this sector or they're aging out of practice. And so it creates a bottleneck, it creates challenges for us to find those professionals that we need to support our work. Also, I mentioned COVID. Title companies have been extremely overwhelmed with closings, and it can be very difficult, and in many cases far more expensive to do title work today than it was 4, 5, 6 years ago. So we really need to be intentional with the resources that we have to achieve the conservation outcomes of our strategic plans. And finally, on this slide, the last thing I make note of is negotiating conservation easements can be collaborative. I wanted to sort of set the tone here. This was brought to my attention by somebody at LTA when we were preparing for our conference, and she really stressed the importance of conveying to land trusts the fact that sometimes your professionals are coming into these transactions with the baggage of their career, right? And so if you go out and you get an attorney, that attorney is probably more experienced negotiating things other than conservation easements than they are negotiating conservation easements. That can lead to a more adversarial than necessary approach to negotiations, approach to a transaction generally. And that isn't always the most effective way to achieve a conservation outcome. So I just left a citation to a book called Getting to Yes, Negotiating Agreement Without Giving In. That book sets out some really wonderful principles to a different approach to negotiations. So into the meat of it, LTA Standard 8, land trusts carefully evaluate their conservation projects. What does this mean? Project selection criteria and public benefits, which is practice 8B. Conservation priorities consistent with land trust mission and goals. Project selection criteria tailored to mission. Document public benefit. I'm putting this into this presentation to sort of set the tone for what we're talking about. We're trying to do our transactions in a way that is more efficient and more effective. So when we're thinking about how we select projects, when we're thinking about how are we documenting public benefit, let's also be thinking about the work product that we're going to need for our own records as land trusts. And can we be more efficient with our resources when we're doing our due diligence? Can we simultaneously be creating, for example, the baseline documentation report? Or can we simultaneously be creating the documentation of conservation values that will be used in conservation easement drafting? So my point is thoughtful preparation of information gathering tools promotes effective and efficient transactions. In the materials, which is linked in the chat, you will find some examples of some thoughtful information gathering tools. Those are tools created by Wisconsin Land Trust. And if you put thought into these information gathering tools, you'll actually be getting, you'll actually be sort of checking the box on some of those work products that are going to come later in your transaction. So project evaluation, 8C, site evaluation, initial information gathering, on-site and remote evaluation. And Dave, I wanted to engage you in this conversation. When a land trust is out doing the initial site evaluation, how can we sort of approach that effort, which takes staff time or board time? It takes resources. You have to create a documentation, a paper trail of that effort. So while we're out there doing the site evaluation, what are some other things that we can be doing at that time, or some other work product that we can create simultaneously to create a better transaction in the long run?
Thanks, Chris. I mean, you touched on a big thing right there. The site evaluation itself is key, especially for organizations that are LTA accredited or seek to become LTA accredited. This is a critical document, is a necessary document, I should say. So you want to completely document your the property, your impressions of the land, but you can use that initial visit for more than just a cursory overview. If you think there's a decent chance that you're going to be placing an easement on this property, now's an opportunity to start gathering information for the baseline documentation report, whether you're going to write that internally or whether you're going to farm that out to someone like myself. Get an assessment of the vegetative communities on site, the health, existing improvements, things of that nature. You're going to need a lot of this for the site eval in the first place, because if you're going to bring this to your board, they're going to want to know what the possible drawbacks are, what the possible problems that you might encounter, as well as the benefits of the site itself on a conservation level.
And so in doing that, what are we looking at? We're looking at, publicly available data sets on our computer online, usually at county websites. Dave, you've done a lot of this work for me on projects. How are you going about to sort of do that site evaluation, even though you're not the boots on the ground person?
Excellent question, Chris. Thank you. A whole lot of this, to your point, is available online now. It's wonderful that we live in the mid-21st century. First thing you're going to want to do is verify the boundaries. And surprisingly enough, more often than not, there's some confusion with respect to where those boundaries lie. Sometimes it's only 20 feet this way or that way. Sometimes it's significantly more. Check county data. It's not going to be perfect, but most counties do have an online resource where you can look at property lines, usually accurate to within a few meters. I, for one, also use these public databases to look at things like topography, soils, sometimes existing structures if something's otherwise hidden by vegetation. And I might not be on the site, but I'm trying to get a sense as to what's out there. Wetlands. Sometimes threatened and endangered species. All of this information, or most of this information, is available in either an online format, or you can get it from the various government agencies that create it, sometimes by signing an agreement, sometimes they'll just say, yeah, sure, it's public, here you go. Use that, especially in these early stages. Use it to help decide whether you want to move forward with this project, and also use it to build a better understanding of the property itself. Again, if you do move forward, you're going to need a pretty darn comprehensive summation of what's out there. So start here, start early, and use that public data. It's not 1995 anymore. We don't have to take soil borings. We don't have to go out and try to delineate the wetlands ourselves. A lot of that's done at a high level.
Right. So under standard 8C, you're required to do the site evaluation. You're required to identify and document the conservation values. You're required to compare them against your project selection criteria. The purpose of that being you want to make sure that this project actually aligns with your mission. We'll come back to that in a little bit. And then you also want to evaluate threats to conservation values. One of the Dave, I remember a project that you and I worked on where I think it was a 176-acre farm. All the land that we were protecting was farmland. I'd say there was about 20 acres of woodland, but primarily farmland, tilled agricultural land. But immediately adjacent to it was a subdivision. And within that subdivision, there were homes that were routinely using that property line to dump materials. The only way that we were able to identify that as a threat to the conservation values, meaning if that adjacent neighbor continues to encroach on that boundary line and that dumping of material begins to happen on our property or on the conservation property, all of a sudden we have an enforcement threat, right? And with Dave's work and with our sort of due diligence of being out in the field and gathering this information early, we're able to develop a relationship with those neighbors. We're able to talk to them about what we're doing and sort of nurture this relationship of respect. And all of that goes to creating a much better conservation project in the long run. But we got to get out there early and start that practice.
And you can use those early visits also to identify potential threats and decide if you even want to move forward. Matt and
That's right.
Danny, I see you're both on this call today. I worked on a project with open lands last year up in northwestern Lake County. And when I was out visiting the site, I couldn't see this from an aerial photograph, but when I was out there, I discovered that there's a residential road that dead ends at this property. And it's been used for many, many years by local residents just to discard landscaping waste. That's something that would have to be addressed. And if we hadn't gotten out there and looked at that before moving forward with the project, it could have been not a serious problem, but a significant one all the same. You can identify that early on, build maintenance, build management, build monitoring costs into any endowment that you might negotiate. Just figure out what's out there, and better to do that really early so you can decide whether you even want to move forward with the project.
Yeah, and I think that all speaks to this last point on this slide, which is evaluate the potential risks. And what that really means is the reputational or organizational risks, and also the risk to the land trust community. You know, if you're out there up front negotiating, or not even negotiating, but communicating with adjacent landowners about what you're doing, it goes to great length to sort of preserve your community reputation, and have people supporting the work that you're doing, even if you're not actively protecting the land that they own. So it's really important. And I put that reference down at the bottom. The baseline documentation report, it's not just a document that LTA dreamt up and decided to force all land trusts to do. It's a document that is required by the Treasury regulations in order to qualify for a tax deduction for a conservation easement contribution. There's a federal regulation citation at the bottom that you can look up if you're interested in reading more about that. But the language quoted there is from LTA, and that LTA language is almost verbatim pulled from the Treasury regulations. So it's not an optional document, it's a required document. So if we have to do it, and with the mind of how are we efficient with our limited resources, we can leverage the work that we're putting into our BDR, our baseline documentation report. I'm sorry, we can leverage the due diligence we're doing at the front end of our transaction to get that baseline documentation report done, and done well. So the next standard is project planning, protect conservation values and further mission. So this is a requirement for an accredited organization. If your mission of your land trust is to preserve equestrian trails, right? You're certified, or you're a 501c3 organization, land trust, you use conservation easements to achieve your mission of preserving equestrian trails or any sort of recreational trails. And all of a sudden you have an opportunistic project appear in front of you, and it's this beautiful wetland, and putting equestrian trails in would be very disruptive to the ecosystem. You have to be able to support a decision to not take that transaction, to not take that opportunity, for a number of reasons. But let's say, for example, you elect to do it, and you elect to move forward with that transaction. You need to be aware that that decision to take something that doesn't align with your mission right now is going to have repercussions for your accreditation, or either your accreditation or your ability to be accredited in the future. So in order to align your conservation values, the conservation values of the property, with the mission of the organization, we need to be thoughtful at the outset. We need to do our homework. We need to understand, is that wetland property going to do well to host an equestrian trail or other recreational trail? And we need to document the due diligence that we're putting into that research. So for something that maybe isn't so opposite ends of the spectrum as wetland and equestrian trail or recreational trail, think of something that might be slightly more aligned, like you're an agricultural land trust, and you have an opportunity to protect a property that is 50% agricultural land and 50%, southern mesic forest. You can begin to use the work that you're doing in assessing that property to inform your negotiations of how you're going to protect that property. What type of easement provisions are you going to, ask to be included in that easement as you're drafting it? Or maybe, what are you going to ask for stewardship contribution? What do you guys call them down there? We call them stewardship contributions, endowments.
We call them endowments down here, though I think the verbiage is probably in flux as well. I'm going to defer to the folks in the field who actually negotiate these things. If anyone has a different term for it, please take yourself off mute and pipe up now. There's an overwhelming response. Endowments it is.
Stewardship and defense contribution.
Exactly.
There you go.
We do not use endowments because that's pretty much permanently restricted. Permanently
Smart.
restricted.
Right. So the point being that, when you're assessing the property and you actually take the time to document the consideration of how does this property align with your mission, you can use that work to begin to negotiate other aspects of this transaction. It'll inform your BDR. It'll inform, what type of stewardship contribution you're really looking for. And then, of course, assess your stewardship implications, the capacity to meet obligations. You want to do this early in the process. You want to do this before you've invested in your attorney reviewing a legal document. You want to do this before you've reached out to partners and signed MOUs and things like that. You really want to be able to understand, are we going to have the capacity to do what the landowner is asking for us from us? So we want to do that earlier.
That's basic. A lot of times it's, hey, just come out once a year and make sure nobody's built a house on the property. Some easements do include requirements that the land trust provide restoration management services. But even for those where you just have to come out once a year, make sure that you can get out on the site. Make sure, is some of this property isolated? Are you going to need a drone? Are you going to be able to manage 30 or 40 or 50 easements? Because you're going to be adding to your portfolio every year. Again, this can be minor, it can be major. It's just something to keep in mind.
Something that I've noticed in my time, consider landowner relationships when you're thinking about monitoring obligations. Is it going to be a nightmare for your organization to have a relationship with that person long-term? I mean, that's a real consideration.
Or their successors.
And their successors. Is it going to be problematic to your organization to get a time out on the property to monitor? And if so, maybe you still want to move forward with that project, but maybe it's going to change the way you draft the language around monitoring access in your easement. Maybe you don't require permission to be granted from the landowner. You just create the opportunity without permission for the land trust to enter the land once a year.
And in that same vein, keep in mind the nature of the folks that you're working with. Are these people or organizations or groups that might have a contentious relationship with others in the community? And if so, could that adversely impact you? An extreme example, but one that I like to use because it's easy for everyone to understand, is a land trust out in New York who put a conservation easement on land owned by the former and recently indicted president. That has not done wonders for their public, their PR, because there's a sense that perhaps this was just done for financial reasons, might be something underhanded. And again, that's an extreme example, but always remember that you're going to be tied to the owners of these properties for good or for ill. And
also, when you're making the considerations around the stewardship implications and your capacity, I don't like to create the impression that if you get to know, then your relationship with that land ends there. It may very well be that you have a wonderful conservation organization partner in the community or a national conservation partner that property would align with perfectly. And so you can be a steward of that property from your relationship with the landowner coming to you, asking about it, handing it over to the more aligned organization. A lot of times land trusts will operate in a silo as if other land conservation organizations don't exist around them, or overlay them, if you will. Perhaps a county would be interested in taking an easement on that property. Perhaps the Nature Conservancy or American Farmland Trust, a national organization. So just because we get to know on that for our organization doesn't mean our relationship with that landowner or the land itself needs to end there. We can actually achieve really great conservation outcomes through partners. So LTA standard number 9, this is sort of the meat and potatoes of what makes a sound transaction. Land trusts work diligently to see that every conservation easement transaction is legally, ethically, and technically sound. 9A requires legal review and technical expertise. The practice: obtain legal review of every conservation easement transaction by an attorney experienced in real estate law. I strongly encourage you to not just go in the yellow pages of whatever today's equivalent of the yellow pages might be, Google search, and find any old real estate attorney. A conservation easement transaction, especially a conservation easement transaction with tax implications, is so nuanced and requires somebody with the experience of doing that, both for your organization and for the landowner. Having an experienced conservation attorney involved in that transaction, although it might be expensive, it might be difficult to find them, it can add so much value to your conservation portfolio over time, because the work that you put in upfront with somebody who's experienced pays off 10 times, 20 times in the future when you have an issue with that conservation easement. Inevitably, you're going to have an issue with a conservation easement. You never know which one, and you never know how frequently. But if you've done that work up front with somebody who is experienced with the case law, experienced with the tax implications, experienced with the negotiations, just experienced with the sort of overall function of a conservation easement, that investment pays out over time.
And conversely, if you work with someone who doesn't have experience or doesn't learn quickly on the ground, you can run into some serious problems. I've encountered several situations, several easements, not in my personal work, but just in the field in general, wherein the landowners were not able to take the charitable deduction that they were expecting because the transaction was not handled appropriately from a legal side of things. There are certain steps that need to be taken, certain boxes that need to be ticked, and if those boxes are not ticked, the IRS will disallow the easement, and there is no takebacks.
To be clear, they will disallow the
deduction,
deduction, right? The easement will stand, but the deduction will be disallowed, which does not make for happy landowners. So similarly, appropriate technical expertise for other areas related to this transaction, not just the easement drafting or review, but financial expertise, real estate expertise, tax, scientific and land and water management. Bring those experts in early in the process. I consider Dave to be a wonderful resource to Wisconsin Land Trusts. I always recommend, if they don't have somebody with some experience doing baseline documentation report or just generally assessing a property, or if they need help with GIS or they need help mapping something, Dave is an expert, and Dave is very good at what he does and can help in many more ways than just creating a nice looking baseline documentation report. I'll say that.
You're too kind. Thank you, sir.
I added this red text on the bottom: skilled craftsperson with proper tools, right? That's really what you're getting when you bring the experts in with the experience. You don't have to do this alone. People are out there to help. So environmental due diligence. For every conservation easement transaction, we are required to do some environmental due diligence. And a common question is, what does that look like? Well, LTA helps us a little bit by saying we conduct or obtain, quote unquote, preliminary environmental investigation, transaction screen, or phase 1 assessment, and then take steps to address significant concerns. So those terms, they come from a certain area of law that deals with hazardous contamination. the purpose of LTA requiring this level of due diligence is to protect a land trust from liability. So under this area of law, it does not necessarily matter that you were not the operator that caused a hazardous waste spill. What matters is that you are now the owner of that hazardous waste spill. And they can attach liability to you even if you did not stash 50, gallon drums in the back, as we're all familiar with that movie. But if you own it, you can be liable for it. So this is a very, very important piece of due diligence. Why not do this with an eye towards satisfying the other due diligence requirements that we have for an easement transaction? Dave helped me with a very complicated transaction. I'm thinking of the Kukler transaction right now. This was a very significant fee simple contribution, but the lesson applies to this, in which we did our preliminary site evaluation. And with the organization I was at, the preliminary site evaluation did include a preliminary environmental screening. So we're checking 2 boxes with 1 site visit. And the preliminary site assessment revealed to us that we had outdated transformers on the property, and we also had a buried oil tank, I guess you call it. And so that sent up red flags. We're taking this property in fee simple. We've got transformers that may very well contain PCBs, and we have a buried oil tank. And so it caused us early in the process to say, hey, we want to get some more information about this. And we solicited an environmental engineer. They came, they did a preliminary phase 1 assessment for us. And with that preliminary phase 1 assessment, we then turned to Dave. Dave turned that I'm a lawyer and I sort of speak gobbledygook, but when it comes to scientific gobbledygook, like that's not my ballgame. So I was able to turn to Dave, and he took a lot of the substance of that assessment and incorporated the essential information into the baseline documentation report. Now we've checked a bunch of boxes without spending money over and over and over again to really achieve the same outcome. But we only did that with sort of strategic planning from the outset. Dave, do you want to add to that at all?
I think you've covered a lot of it. Now, do you need a phase 1 for easements? Not necessarily, no. You definitely need it for fee property for the reasons that Chris just articulated, but it can be useful, even if it's not a full phase 1 environmental impact investigation. If it's just something that one of those documents that you purchase online where you assess the presence of hazardous chemical spills and things of that nature. Because if there is a problem on the site that's going to have to be remediated, that could impact the conservation values, or it might even impact the maintenance of the easement itself. If someone's going to have to go in there and clean things up, or cut down 20 acres of oaks to get to a leaky oil tank, that's something you want to know before you put the agreement in place. So I can't recommend highly enough at least doing some preliminary investigations or basic investigations of any property of any significant size. I mean, does this apply if it's 5 lots in the middle of a residential subdivision? No, probably not. But just use good judgment.
Right, and to that point, David, it might inform, again, getting back to that negotiation piece. If we take a collaborative approach to our negotiations for an easement transaction, having something turn up on a preliminary environmental investigation, it especially early in the process, it creates an opportunity to say, hey, we're really interested in this property. It aligns with our mission. We need some help from you to achieve this conservation outcome. If you in other words, there's that tax benefit, sort of low-hanging fruits incentive for them. But if we want to get there, if we want to get this land permanently protected, we're going to need some help from you. You're going to have to invest in a little bit of cleanup or mitigation around these transformers or the oil tank, the buried oil tank. Better to do it early than later. So identify property boundaries. this is one of my favorites because it always generates a little bit of discussion. LTA requires that we identify the property boundaries. Well, what does that mean? Does that mean we need to go out and get a survey? Surveys are very, very expensive, especially for large properties with sort of meandering exterior boundaries. So how do we identify it? Well, LTA gives us a little bit of guidance. They want to see a legal description, and they want to be able to identify the physical boundaries, not only on a map, but also on the ground. So how do we do this, right? Well, this is where Dave's sort of expertise has paid benefits to me personally and the organization I was with. We had a 500, I'm thinking of Duplo.
Yeah.
We had a 560 acre something project. We worked on it for 2+ years, and we had management zones within the property. We had a river running through the property that split a couple of parcels, and I got a quote for a survey. I wanted the perimeter boundary surveys and surveyed, and I wanted the interior boundary survey. The quote came back at $55,000 to do this survey. Right, that's cost
5,500, folks.
55,000, 3 zeros after 2 5s. That was cost prohibitive. We've got this pristine farm, one of the first certified organic farms to Organic Valley in the state of Wisconsin, 3rd generation. You know, it checked all the boxes, and river 1.6 miles of a river meandering through it. I mean, it was phenomenal, and we couldn't come up with $55,000 for a survey. And so I called LTA and I said, what do you really mean by identify and describe the boundaries of the property? And in much conversation with Dave, we learned that Dave's ability to identify a GPS point on the ground had a certain margin of error. We learned that the monitoring technology that we were using to monitor boundaries had a certain margin of error. And so we did a little bit of math. We took it back to LTA and we said, hey, if we're able to identify these boundaries, we have a legal description. If we're able to monitor these boundaries by legal description within a certain margin of error, is that acceptable to you to meet standard 9D? And they said, absolutely. And so we use technology and we use a little bit of creativity to get a yes on that one with LTA.
And to give a little context for those who might be wondering what interior boundaries mean, sometimes in Wisconsin, they divide things into zones. We don't have that as often here in Illinois, but it's not unheard of. Building zones are the most prominent example. If your easement includes a building zone, that is an interior boundary.
That's right. So if you can find a way to not have to survey and monument an interior boundary, and you've got handheld monitoring device, plus somebody like Dave Holman to generate GPS points for you off of a legal description, you can actually get around that survey cost for your easement transaction, which is a huge benefit. Caveat, I'm the attorney and I always draft a provision into my easements where it says an interior boundary may be identified by survey if a dispute arises based on that, on the ability to identify that boundary. So it's a bit of a belt and suspenders approach, to say.
Quick time check. We're at 3:45.
This is good. I've got 2 more slides here. So now so basically where we're at now is we're sort of getting towards the end of our quote unquote due diligence phase, and we're moving into actually drafting the easement. So 9E, the standard 9E requires that each conservation easement be individually tailored. There is no cut and paste, right? You cannot take an easement from property 1, lift it and change name in it and apply it to easement on property 2. If you ascribe to that approach, you're creating challenges for LTA accreditation and just general risks to your organization. You really want to be thoughtful about drafting your easement to meet the specific needs of that property and the landowners involved. One anecdote that I like to share is that oftentimes in the land trust community, we can think about the land and we think about how do we protect this land. But it's also true that in order to protect that land, we have to engage with humans. We have to engage with people. And every person and every family has a story. And I like to think of a conservation easement drafting process as an opportunity to capture the story that that family has with their land and match the easement to that family's story or their history. If it's a second, third, fourth generation of a family owning that piece of land, they're going to have childhood recollections of playing by the river. They're going to have memories of how that wetland moved from point A to point B over the 100 years of ownership. There's so much that goes into a piece of land, much more than just a snapshot set of data about the land today. The drafting process is the opportunity, in my opinion, along with the baseline documentation report, to really capture and tell that story. And I just love thinking about it that way. It just adds so much value to the work that we do. So carefully individually tailor each easement to the property. All that work that we've just talked about doing can inform how I draft an easement. I also want to make a point that you don't need an attorney to draft your easement. You need an attorney to review your easement. If you're a board member here, invest in your staff. Invest in getting your staff trained to do this due diligence work. Invest in getting your staff trained to draft an easement. It saves you money in the long term, creates a better work product, and allows the person who has the relationship with the land and the landowner, your staff member, to actually create the agreements that will be binding on that land in perpetuity. Invest in your staff. And the other piece is that the conservation easement must identify the conservation values. Dave and I go back and forth about what the best way to do this is. Up here in Wisconsin, we're seeing a trend towards actually articulating the conservation values in the easement itself. Dave has shared with me that a common trend in Illinois is for the easement to simply reference the baseline documentation report to see the conservation values, either or, but
though even then, this has also been historically common, and it hasn't gone away yet. Down here, we'll also often put some conservation values in the whereas at the beginning of an easement. For example, if one of the values is that the easement provides scenic vistas, that's probably going to go in the easement itself. And whereas this thing's visible along such and such a road, I mean, it seems stupid to those of us who aren't attorneys, but it's actually essential because the conservation values are what are the basis of any type of charitable deduction that the owner is going to take. So you want those clearly spelled out in some form or another, some way, and you want all of them spelled out and then documented within the BDR.
That's right. And not only do we want them spelled out, but it's those conservation values that provide the basis for a restriction that will come later in the document. A restriction that is not tied to a recognized conservation value could potentially be found as unenforceable if, well, I won't get into it. We don't have time for that, but there are certain scenarios where a restriction that has no conservation value associated with it could potentially be unenforceable.
Which is an issue that Illinois and Illinois Land Trust that I work with has faced. So this is not just a hypothetical that Chris is articulating. In fact, it's the subject of an ongoing court case.
Right. So we like to articulate those conservation values and then have our restrictions and covenants in the easement be directly related to those conservation values. You could even go so far as to say, in order to protect conservation values or the conservation value X, development is not allowed, whatever the case might be. So finally, and I'll just briefly touch on this, but title investigation. I think LTA does a solid disservice by putting this as 9F. Only because, and also in the checklist that I shared with you in the materials, it's late in the checklist. Don't do it late in the process. Do it early in the process. Do it when you're beginning to engage the other professionals around the transaction. You've probably already done your initial site investigation and seen that this project checks a couple of your boxes, probably going to align with your mission. Go to a title company, get them to do some title work for you so you can see the legal description and what other encumbrances exist on that property. Okay. Title work is super, super, super important. Are those encumbrances negatively impacting our conservation values? Are they sitting on a portion of the property that makes some of your restrictions or provisions unenforceable anyways, because the encumbrance would supersede your easement? Do we need to subordinate to anything? Do we need to subordinate a mortgage? Do we need to reconcile our mineral rights? Do we need to make our mineral rights part of the property again prior to conveying a conservation easement? All of that stuff takes time. All of that stuff takes money. It's better to know what you're getting into early in the process instead of getting through the negotiations, drafting your easement, doing the BDR. Now we're 3 weeks away from closing. You go to a title company and all of a sudden you find that you've got 15 encumbrances that are going to make protecting your conservation values almost impossible. Do it early in the process, update it before closing, have that reviewed by an attorney. What Dave and I just talked about today is developing a relationship between the two of us where I can send him my title commitments and he's going to map the encumbrances for me so that I can do a better job of informing my clients as to the risks that are presented by those encumbrances to the conservation values. That's my last slide.
Cynthia, do you want to open up to questions, if any?
Oh, yeah, definitely. And if you want to stop the share, we can bring everybody forward if you want to. There's nothing in the chat, so if you want to just show us your face and take yourselves off mute and say hello, and if you have any questions. If not right away, I have a question for everyone here, and then if you can respond, that would be great. I'm very curious about how our conservation land trusts in this area, for example, what conservation lawyers do you use? How do you go about that? Do you share with other land trusts those services? Chris, for example, works for Gathering Waters. When land trusts join, they can opt for that membership that includes his services. So, which is a very interesting model. But I'm kind of curious, who does everyone use? Is there like one person everyone goes to, or do you have a board member who's a volunteer? So anyone wants to jump in on that, please do. George Covington. Yes.
George Covington, that's a known commodity.
Yep.
So Cynthia, out this way, we have an attorney that does pro bono for us. And he's
Nice.
very knowledgeable. He's been doing this for, I don't know, 5-6 years. Looking at our land deals, both fee properties and easements.
That's awesome.
That's fantastic, because you have a fair number of them. He really knows what he's doing. Because I've always been impressed with the quality of the documentation that you send me for both easements and fee.
Yeah, we're fortunate.
And anybody else? Yeah, I guess that's the big question is having someone, as Chris mentioned, a conservation lawyer who practices and not just real estate. I can see as a coalition like PSCC is similar to Gathering Waters in Wisconsin, about having providing that as a service of sorts. So yes, I think that would be great. Maybe in 10 years we have a Chris. And
She's
that
gonna
could
try
be
to get you down here again, Chris.
I give up on that. Poor Chris. I say that every time I see him.
So there's a number of models out there where state coalitions are getting legal services to land trusts, and ours is just one, and it's just the brainchild of a bunch of people in a room trying to do the best for our land trusts in Wisconsin. Not to say it's the best, but for example, the Oregon Coalition of Land Trusts, or a Coalition of Oregon Land Trusts, COLT, they actually have a pro bono service where they basically maintain a directory of attorneys willing to contribute pro bono time. They get trained, they have training, important. And the coalition farms out work that comes to them through their coalition of attorneys. That's another model that's out there.
Yeah, Sarah mentioned that. I think that's great. We'll look into that. And actually, I want to thank Sarah because with Grand Prairie Friends, this was her idea as a topic for us to cover. So thank you to Sarah for helping spearhead this idea, and glad that we could make that happen. Always open to ideas from all of you.
I was just going to say that, this presentation was an absolutely abbreviated version of what we did at the conference. And so it's that everybody's aware of kind of what happened at the conference. Basically, what we like to do in our Anatomy of a Deal presentation is actually create a hypothetical land transaction. And then we break the group up in the room into 4 or 5 different land. I think this year we did 6 land trusts. And then we give each of those land trusts different sets of considerations. Maybe they're a land trust in their 2nd year. Maybe they're a 30-year-old land trust. Maybe they have $1 million budget. Maybe they have a $20,000 budget. Maybe they're all volunteer. And we create all these different circumstances for these land trusts to navigate the same transaction. So we have one transaction, 6 different land trusts, and we sort of guide them, we guide the group through some of these considerations. And then we ask them, how would you do this deal? Would you do this deal? And we get feedback from them that really, really highlights the differences that the different types of land trusts, the different decisions that the land trust would make throughout the way. So it's a really great exercise, but certainly one that's A, more suited for in-person, and B, you need more time.
Yep. And it was fun. That was very fun. Anybody have any other questions? We've got 1 more minute. Otherwise, I will. Yeah, Daniel?
Yeah, I had a quick question. Hi, I'm Danny from Open Lands here in Chicago. I had a question for Dave and Chris regarding when you were speaking a little earlier about reviewing phase 1 ESAs. What would you recommend would be a good time to do that during the selection criteria process? And how important of a step would you consider that to be?
Chris, you want to start with this? I think
sure.
We both have our opinions, but I'll defer to you to start.
Yeah. So first of all, I met some of your colleagues out in DC at Advocacy Days. It was nice to connect with some of them. So you framed the question around a phase 1 specifically, but I will just be clear that phase 1 is not required, but it may be valuable in certain circumstances. So what I like to do, and what I did at the last organization I was with, is to build into my preliminary site evaluation some points of investigation that are going to cause me to either confidently say no to a phase 1 or go to a phase 1, right? So there's like a fork in the road I create the scenario that's going to present a fork in the road during the site evaluation. So it's after my site evaluation, at which point I'm talking to my committee, or I'm talking to my board if I don't have a project committee, a preservation committee. And it's at that point, very early in the process, that I'm going to engage an environmental engineering firm. And the first thing that I'm engaging them on is what I could consider preliminary screening. Does your preliminary screening match my initial site assessment, or am I not informed? Did I make a bad assessment? Did I make an error here? And if they come back and they confirm my concerns, then I'll ask them to proceed to a full phase 1. So I do that early on in the process. Now, there are financial considerations to be made, obviously, right? So depending on, is this a project that we're going to be able to turn around and have some good PR around and turn into a good fundraising campaign? Maybe that's going to cause me to say yes to a phase 1 quicker than one that might not be so highly visible. But it's that early in the phase that I'm making a decision around phase 1.
Danny, I think it also revolves around the nature of the property. For example, I'm working on a couple of different projects, one of which is with you, one of which is with another organization. The second project is a 5-acre lot in a municipality. I am not worried that there is there have been any historical anomalies with this site. It was never used as a dump. There are no buried gas tanks there. There's no history of development at all. Then look at something out in the Hackmatack region, like you guys work with. There, I think I would at least want to do a basic high-level review, but maybe not with an engineering company, but at least order an EIS statement to see if there's anything out there that should raise some flags, to Chris's point, that would encourage you to then take things to the next step before you spend a lot of money and staff time discussing or debating whether you want to acquire this property in the first place. Again, that's a bit outside the scope of this session since we're talking about easements, but I think it's worth mentioning.
Well, we're a
I'm
little.
gonna follow.
Oh, go ahead, Chris.
Oh,
Go ahead.
I'm okay staying on a little bit if we're good letting this run.
Okay, I will invite people absolutely to do that, but I will sort of officially let you know that September 26th is our next Conservation Connector. And that is on nature-based solutions and the Clean Water State Revolving Fund. The speakers are from Quantified Ventures. So September 26th at 2 p.m.